on. I'm Nandakma from the Department of Environmental Law and Order, and it is the privilege to speak before you as a Master of Ceremony for this distinguished session. With immense pleasure, I would like to introduce a true luminary in the field of legal education and research. Former Vice Chancellor of Tamil Nadu, Dr. Ambedkar Law University, Professor Dr. P. Vanagamudi Sir, a towering intellect and revered academic. Sir has left an indelible mark on legal landscape. It is with the great admiration and deep respect that we acknowledge the extraordinary dedication of Sir, a true stalwart in the field of legal education. Today marks the 10th lecture in his enlightening series of legal research methodology, a testament to his unwavering commitment to the dissemination of knowledge and his passion for nurturing curious minds. Sir's journey through this lecture series is nothing short of monumental. With each session, he has meticulously unraveled the intricacies of legal research, illuminating pathway for aspiring scholars and seasoned professors alike. His ability to blend profound theoretical insight with practical application exemplifies the hallmark of true academic visionary. Such dedication is rare, and it speaks volume about his enduring love for teaching, his pursuit of excellence, and his belief is transformating power of education. Saw's commitment to empower the next generation of legal minds is not just inspiring; it is a legacy in making. I would also like to take this opportunity to acknowledge and thank the Honorable Vice Chancellor of Tamil Nadu, Dr. Ambedkar Law University, Colonel Professor Dr. N. S. Santosh Kumar Sir, whose leadership has been instrumental in creating a thriving academic environment. We also joined by our esteemed Dean Professor Dr. V. Balaji Sir and the Registrar Professor Dr. Gauri Ramesh Ma'am and our PG Director Professor Dr. Kumudaratna Ma'am, along with our faculty convener Dr. N. Anbarasi Ma'am and all the heads of the department. I welcome you all with great respect and gratitude. In previous sessions, Saw has once again guided us through an enlightening exploration of empirical research in law, particularly in the realm of Supreme Court judgments. He broke down the misconception that legal research was purely quantitative, demonstrating how advancement in technology and artificial intelligence have made empirical analysis indispensable. Through the lenses of descriptive statistics, he showed we can decode the nuances of the judicial decisions, particularly those surrounding the Indian basic structure doctrine, a living testament to our constitutional resilience. He also took us to the intellectual journey comparing the judicial philosophies of two legendary Chief Justices of India, showcasing the evolution of legal interpretation over time. He illuminated the role of modern content analysis in the revealing pattern judicial behavior, calling for the fresh perspective on relationship between technology and law. We delved into the complexities of constitutional amendment and the Supreme Court's role in ensuring the basic structure of the Constitution remain untouched by transient political majorities. In his concluding remarks, Shaw has emphasized the power of hypothesis testing and content analysis in modern legal research, encouraging us to explore judicial behavior with both rigor and creativity. This lecture was not just academic. It was a clarion call for researchers to embrace innovations while remaining anchored in the timeless principles of law and justice. In today's session, Saw will discuss on artificial intelligence and the content analysis of Supreme Court judgments. Today's discussion will promise to bridge the realm of technology and law. Without further ado, I now hand over the session to the esteemed speaker, Professor Dr. Vanagamudi Sir. It is with the great pleasure that I turn the session over to you, sir. Thank you.
Thank you very much for the nice introduction given to me. I am very much impressed. I want to be up to your expectation. At the outset, it's my pleasure and happiness to thank the Honorable Vice Chancellor, Colonel Professor Dr. N.S. Santosh Kumar, and the dynamic directors of the School of Excellence in Law, various department directors, and the cordial coordinator, Dr. N. Anbarasi, and his dynamic team, who is responsible for doing all the background work. It's my pleasure to share my ideas with you. I have only one ambition. What the knowledge, limited knowledge that I acquired from the society, from the institution, I would like to share with you and like to transmit this knowledge to the younger generation, thereby to the future generation. With this goal, I'm doing this one. So it's my pleasure, rather, it's the pleasure of the students. With this introduction, today let me enter into a very interesting topic, artificial intelligence and content analysis. The first concept, everybody, every academician, every professional are very much interested or very much immersed in artificial intelligence. Second one, for the past 3 or 4 sessions, I have been again and again telling about the content analysis, and I have been pointing out again and again about the Supreme Court judgments and the relevance of Supreme Court judgment that can be analyzed empirically or based on descriptive statistics. So to proceed further, in this context, I have taken this topic, artificial intelligence and content analysis of Supreme Court judgments, Supreme Court of India's judgments. Before proceeding to the 6 subheadings, I'd like to give a detailed introduction. Introduction may take some more time. It's not a problem, but a better introduction will solve half of the problem. People are thinking, more particularly lawyers, they are thinking in what way this artificial intelligence will be helpful to the students of law and the legal professionals. But knowingly or unknowingly, we have been in artificial intelligence. I have come across the statistics. India, everybody is saying that it's still a backward country. But next to the United States, India has the largest number of persons who are connected. 50% of the Indian population, they are connected by internet. So connectivity, well-connected people are well-informed people. Well-informed people are developed people. Financial development, economic development alone is not an index of modernization or development. Information development is equally important. So in this context, more than 50% of the people, Indian people, are connected by internet. It's an index of development. In that context, we are also fastly developing. And I come across another important statistics, let alone be 50% of the population. What about the graduates? What about the professionals? So whether we have food for the next time or not, whether fees to pay for the next year or not, the moment when we enter into a professional course, we want to have a smartphone. We want to have the latest gadget. So in that aspect, we are unknowingly entered into the domain of artificial intelligence. 90% of the graduates in India, one way or other, they are having the smartphone or connected by artificial intelligence, everything. Therefore, in this context, artificial intelligence is inevitable. And I'm trying to point out how can we use this artificial intelligence? Because today, there's a very big problem is going on in the society. So from morning to evening, this guy is going on looking after a mobile, what he's doing in the mobile. There's a criticism leveled against by parents. Even children, 5 years or 6 years, they are also addict to this one. Yesterday, I come across a beautiful talk. In this talk, they are saying whether this YouTube seeing or mobile seeing is an addiction or not. If it is an addiction, whether the United States banned this addiction or not, they categorically said no. It is not an addiction. It is information connection. That way they are pointing out. So the only thing we have to do is when we are using artificial intelligence, when we are using this internet, whether we are properly channelizing our time, energy, everything on the area which we ought to. If we focus more on the area that is useful for development, information, education, the level we will go up. If we go on another area, different area, or prohibited area, or banned area, then our life will be doomed. So it's like an auto bomb. It can be used for electricity generation, or it can be used for destruction. Either way, we can use it. It depends upon the ability of the youth, ability of the parents to control, ability of persons to channelize this one. So in this context, I am pointing out, use this artificial intelligence in a prudential manner. If you use artificial intelligence in a prudential manner, you can use your energy in a productive manner. I have come across another statistics that anybody who enters legal professionals, if they are using artificial intelligence, they are saving 80% of their time. So who is an expert in artificial intelligence and who is an advocate, he is using or saving 80% of this time. Therefore, my dear young students, young researchers, please try to understand the nuances of artificial intelligence. You may ask me, sir, I am very much interested in artificial intelligence, but what is this one? Whether can I able to understand this or not? Anybody can understand artificial intelligence. So India is known for this technology know-how, and every person who is using artificial intelligence need not know how to draft a program for artificial intelligence. If you know how to use the developed program, then it's good. So in this context only, I've designed this lecture of content, artificial intelligence and content analysis to analyze the Supreme Court judgments of India. That way, I have designed this one. So I have a few more observations in the introduction I would like to say. So it's not out of place to say, it's my own statement. An advocate can be an able artificial intelligence manager. An advocate can be an able artificial intelligence manager. And all artificial intelligence manager can't be a good advocate. So there are two things. Advocates using artificial intelligence and artificial intelligence knowing persons. Of these two, who is very important, I can say, and advocates who learn to use artificial intelligence is as powerful as a superhuman being ride on artificial intelligence. So he cannot be competed. I'm not exaggerating things and I am foreseeing things. So prediction is very important in research. I am predicting those advocates who are capable of using artificial intelligence, they are superhuman beings. I'm not simply exaggerating in the sense that artificial intelligence, it has the ability to do things quickly, speedily, accurately. But artificial intelligence does not have the sense or the sixth sense or seventh sense. It is not having the consciousness. It's not having the humanness. But advocates is efficiency, everything. When this knowledge, wisdom is coupled with artificial intelligence, we can say we are a superhuman being. So I expect all the master students, all the researchers who are listening this lecture, I'm expecting if you blend this artificial intelligence in your legal profession, you will be a gem of a personality. You will be a super duper human being, and the future is yours. So why I'm saying for the next 50, 60 years, legal profession, legal practice cannot be subdued by artificial intelligence. But artificial intelligence will be subdued or dominated by dominating all other fields except the legal profession. And India being a typical country, legal profession will be the last profession which will be supplemented or substantiated by artificial intelligence. So don't worry, try to learn the nuances of artificial intelligence. I have come across, like you, I browsed artificial intelligence, everything. I have come across more than 10 softwares are there in the legal profession. And to my great surprise, they are saying, by using artificial intelligence, there is a software, artificial intelligence software called ROS, ROSS, ROS. It is saying to the tune of 80% accuracy. 80% accuracy in legal profession is a very difficult one. 80% accuracy, this judge is going to deliver this judgment in this way. Prediction is very difficult in judgments, but this ROS judgment is capable of predicting 80%. That way, this artificial intelligence going, I will give all these, I will share all these 10 or 1 dozen software that's used in artificial intelligence. And I don't feel it's very difficult to understand this one. No doubt. In 1981, I learned Photon 4 program, computer program. But once I joined the law college in 1985, I totally skipped. I did not use it. But once again, I realized the emergence of artificial intelligence. I began to venture to continue that work. So in this context, the future is for artificial intelligence. So an advocate can be an able artificial intelligence manager, and all the artificial intelligence manager cannot be a good advocate This is my observation. If you want to be a good human being, dynamic superhuman being, please, being an advocate, you learn. All the masters, you are advocates or lawyers. So you learn this artificial intelligence, maybe 6 months time, maximum 6 months time. Within this 6 months time, you can do it. And I think it's not out of place to say one important observation. When I was a vice chancellor in 2014, I was invited to deliver a lecture in Trivandrum by the government of India. It has organized ICT conference, Information and Communication, ITC, Information Technology Conference, in which I was expected to deliver a lecture. I spoke a lecture on research in law, and it is available in YouTube also. There, I requested the organizers, please, at any cost, help us to translate all the Supreme Court languages into Tamil language. That time, my request was simply turned down. It's not at all possible. Now we are in 2024. My request I placed in 2014. It was turned down. That time it was observed that it was impossible right now to translate. But to my great surprise, in 2023-24, all the Supreme Court judgments, most of the judgments, they were translated into vernacular language, including Tamil. Tamil, Malayalam, Kannadam, Telugu, in all the South Indian languages, all these things are available. So what was impossible, what was considered very difficult to translate, now it's possible. It is because of artificial intelligence. It is like a genie. It's like a Budam. It can do wonders. So what I dreamt, it becomes a fact, reality. A dream comes true. I think it's not out of place to share my one more idea. Some of the students, maybe masters, joined masters from a 3 years course. In 3 years course, during my period, some of the engineers, some of the masters in engineering, some of the software engineers, they joined the course. So having come across that one, I deliberately designed a curriculum called BCA LLB, Bachelor of Computer Application and Law. So the only university in India, and probably maybe in the world, that offers a combined integrated course, BCA and LLB, is our university. So I introduced during my tenure with an ambition that all the lawyers, they must be well versed in software in order to excel in that field. So now I realize my dream came true, that artificial intelligence is doing wonders. So with this, let me go on to the topic. Before that, I would like to share one more very important factor. It is the former Chief Justice of India, Dr. D.Y. Chandrachud, in 2023-24, he inaugurated certain initiatives. There were 12 initiatives or 12 initiatives. Just I'll read these initiatives. There, first one is hybrid hearing system. What's a hybrid system? See, judges are coming to the court. At times, judges may be at home. Yesterday, I come across a beautiful concept. Work from home is a popular concept. Work from anywhere in the world is a new concept. Work from anywhere in the world, not in India, anywhere in the world. So connectivity is there. So hybrid system, one person may be in the online, one person may be in the offline. They can be. That system was introduced, and fortunately, at the IIT of Madras, it has an opportunity to work with the Supreme Court of India with reference to translating or doing this information service to the Supreme Court of India. Another very important thing is ICMIS, Integrated Case Management and Information System. It was introduced by Dr. DYC. And another one is EACR, Electronic Supreme Court Record. It was also introduced. Another is Supreme Court of India's online RTI portal. Online RTI portal. Similarly, translating the judgments in vernacular language, it was introduced. So our advocates are online appearance portal. It was also introduced. And similarly, all new e-filing 2.0, the next step in the paperless filing, it was introduced by Dr. DYC. Establishment of e-Seva Kendra, bridging the digital divide. So, use of artificial intelligence to transcribe oral arguments. When the argument is going on, it is automatically translated in English. So, oral argument, it is the result of artificial intelligence. E-Office, ushering the era of paperless workshop. Swadantaram, Su Swagadam. People from Karnataka you may come across. Swagadam is welcome. Swagadam portal, paradigm shift in visitor management. Free Wi-Fi on premises. So it is another very interesting. Initiation of futuristic codes are the next step in innovation. Onboarding of the SCI in National Judicial Data Grid and neutral citation. These are the various initiatives introduced in the year 2023-24. Because of all these things, today we are well connected with all the informations, all the, I have been telling there are 34,000 Supreme Court judgments. Let me correct myself. There are 36,000 Supreme Court judgments as on date. So all these, almost all these judgments, except some of the judgments, which are single judgments, all these things are available in the internet. So thanks to the artificial intelligence, so without any difficulty, we can access all these things. And particularly for the researchers who is very much interested in doing pure research, doctrinal research, or any research which is out and out related to text and judgments, you need not go out of room or office. At home, you can do it. When you are at home, your productivity, your time is saved, everything is saved. So 1/4 of the travel time, other thing, it is saved. That way, this artificial intelligence is helping the judicial system as well as the legal profession. So my request is, my dear students, try to learn. When I learn at this age to some of the nuances of artificial intelligence, anybody in law school, law university can learn this one and have a good opportunity. With this introduction, let me pass on to the topic of the day. So, artificial intelligence and content analysis of Supreme Court judgments. Here, I have given 6 headings. One is the definition of content analysis. Second one is I'm not defining artificial intelligence, I'm explaining artificial intelligence. Then third one is software that may be used in content analysis. What are the various softwares that can be used in content analysis? And for your information, I have taken 2 important articles, published articles for explaining how content analysis is used in through artificial intelligence in analyzing research. So 2 examples of content analysis, research by CATA. CATA means computer-aided text analysis. Computer-aided text analysis. It's a software that can read the text. So this is, and another one is it's our own research, Indian research. It's done by NLU students, National Law University students, Delhi, in collaboration with the Chicago Law School, and this also published. It's a beautiful work, and the students, you must know, because there's a belief empirical research is not possible in pure research or in judgments. It's a myth. I'm going to break all these myths, and my students will follow me, and you can also help me to break this myth. And human-aided human-coded content analysis research in Supreme Court judgments. And finally, factors for the growth of content analysis. My dear students, there is a caveat I would like to say. There are 3 important concepts in content analysis. I don't find I may have time to take all these things. I reserve it. We will take exclusively because it's applied orientation. Unitization of content analysis, the codification of content analysis, and categorization of content analysis. These 3 topics, they themselves require one session. I reserve it right now. Anyway, here and there, I'll point out what are the meanings of this one. So I have skipped that one. Instead of that one, factors for the growth of content analysis is introduced in this one. These are the 6 headings, subheadings. two concept, content analysis and artificial intelligence, two model research, one in India, another done in Ukraine. Ukraine is known for the distress. Their scholars have done research. It is out and out artificial intelligence used case analysis research. And I pointed out these things, and I'll give my conclusion this one. Another thing is, I'd like to give introduction. One is text in the context. Text, wherever we come across text in artificial intelligence or computer analysis, my dear students, please substitute the word, it is judgment. Judgment is a text. The advantage, the beauty of judgment is you are not, it's a written judgment. It's a past judgment. It is a reported judgment. And your analysis, your study, in no way it will affect the judgment. Already it is pronounced. It is part of a law. It is as per Article 142, 141, 142. It is a law of the land. It is followed. So you are not influencing. Another one is in taking unit. Judgment is a unit. And if you want to divide the judgment, opinion of the judge in the judgment is a unit. I'll take this unitization in the subsequent session, not now. So the text is to be understood in the context. Let me tell you, I did a research in personal liberty. When I did a research in personal liberty, I've gone through the the period when our constitution was drafted. I couldn't recall the word. It is drafting of the constitution. So there, the largest number of debates, largest amount quantum of pages allocated for this article, Article 21. So personal liberty. Yeah. So I'm sorry, I couldn't recollect the book. It's available in our library, and there the drafters of the Constitution, the fathers of the Constitution, they contemplated, they thought of Article 21 in a different context. But today, the spirit of Article 21 is in a different context. So what the fathers of the Constitution thought as Article 21 is not now. It is totally in a different. It has expanded its tentacles like octopus. It encroached almost all the areas. My understanding is anybody can take this research. Any person who is interested in doing a research in fundamental rights, do you come across any fundamental right that is not involving Article 21? That way Article 21 manifested. So text is to be understood in the context. So the word 18 worded Article 21, no person shall be deprived of his life or personal liberty except according to the procedure established by law. There they are using personal liberty. In the preamble, they are using liberty of thought, expression, belief, faith, and worship. So whether that liberty and this personal liberty are equated, more than that, Article 21 liberty is all-encompassing. It includes all 368 degrees. Anybody can take a research and you can do it. What are the judgments that are not involving Article 21 if it is like that, if you can turn only after 1978 onwards, the occurrence of judgments invoking Article 21 will be more, and before that it will be less, because in 1950, Article 21 was read in one context. In 1976, in ADM Jabalpur, it was discussed in a different context. After amending Article 359, in 1978, it's momentum gained. So that way, anybody can take it. What I'm trying to say, text. Text means word or set of words. Word means a set of alphabets, set of words, so set of letters. So this text is to be understood in the context. What do you mean by context? Means environment, circumstance. what was the word in one context is the word is same, but the meaning is dynamic. Therefore, my request to my students is whenever you come across text, please try to understand text is to be understood in the context. A text must be equated with judgments. So with this note, let me pass on to the first slide. Here I have categorized definitions into two categories. The first definition is a very appealing definition, that is a literal definition, useful definition, relevant definition. And the second definition, it is divided into classical definition, traditional definition, and subsequently modern definition. So understand this definition, how this content analysis evolved along with artificial intelligence. So as per Klaus Krippendorf, already I've given this book. This is content analysis, an introduction to research methodology. It's a very popular book. It is available in the online, in the internet. You can read that one. So content analysis, he defined content analysis is a research technique. It is a research technique. Methodology includes research technique, but all the techniques are part of research methodology. All inclusive is methodology. So content analysis is that particular technique. What is a technique? Technique is a tool. Technique is a tool that splits or it breaks and helps a person to reach his target goal. To reach the goal, this technique is used. So research technique for making replicable. What's meant by replicable? Repeatable. Scientific research is repeatable. Repeatable is the definition of scientific research. If it is not repeatable, it cannot be satisfying the definition of scientific research. So replicable is repeatable. So content analysis is repeatable. What I mean by this repeatable, if you take ADM Jabal for even now, it is reported, and even now you may come across Justice Khanna's dissenting opinion. So anybody can analyze it, anybody can take into the same result you will come. So replicable, when it is replicable, valid inferences can be arrived at. So when it is inferences are arrived at, the same inference is arrived by any person. So here I'm using the word judgments in the place of text. So here, research methodology point of view, I would like to, my students, you may be knowing that while you are reading a book, you may come across some places they are using 3 dots. So whenever you come across 3 dots in a sentence or something like that, you have to find there must be some quotation, opening quotation, close quotation. So 3 dots comes means I have edited, the scholar edited certain words not exceeding 1 sentence. If more than 1 sentence is edited, then the 4th dot is there. That is the research methodology. 3 means less than a sentence is edited. 4th dot means more than a sentence is edited. So I have edited certain words because all these things are unwarranted for understanding, better understanding. So to the context of their use. So in order to understand the context, this text is to be used, replicable and valid inference. These are the important characteristics of content analysis as far as Klaus Krippendorf concerned. When you find time, when you are interested in doing research in judgments, you please read this book. I have given this book, reference book already. I'll make a request to the Director of Research and Publication to recommend these 2 books. Already I will mention that earlier. Let me pass on to the classical definition. What do you mean by classical definition? Before introduction of this artificial intelligence, how it is used, how it is defined, that's the thing. So Stone, Dunphy, Smith, Ogilvy, these 3 persons, they defined content analysis to mean any research technique. Any research technique. They are using the word content analysis to mean any research technique for making inferences by systematically and objectively identifying the characteristics of within the text or in the judgments. So that way, this whole. So let us concentrate more on the modern definition. So next definition is next slide. Weber. I'd like to say something about Weber. Every student of law must know this Weber. Max Weber. He is a very, very popular sociologist. He has written a beautiful book about India. Here, the book name of the book is Religion in India. The Religion of India. It is his very popular book. So Max Weber, these Miller, these persons, they were German Indologists. They have done a wide research about India. He defines content analysis as a research method that uses a set of procedure. So he uses the word procedures to make valid inferences from text, from judgments. If it is possible to make valid inferences by following a set of procedure, that method is called a content analysis. Is Max Weber's definition. Please keep in mind about this author Max Weber, because subsequently he is also responsible. In his name there is a software. For that purpose you have to keep in mind. So this Max Weber is a very popular sociologist. We have to keep in mind. Then Berger. Berger defines content analysis is a research technique that is based on measuring the amount of something edited. I have edited certain words in a representative sampling or a text sampling text or judgments. Now, I would like to say one thing. Suppose, sir, 36,000 judgments. Is it possible for me to study? Suppose I would like to understand all these judgments. Can I study it? Oh, you can take a random sample. You can take a stratified random sample. What do you mean by stratified random sampling? So every year I can take 2 judgments, and in a period of 10 years 20 judgments. So in 75 years this many. Or you can take I am capable of studying only 200 judgments, I will study only this one. Or on the basis of the 36,000, for every 1,000 I can study one judgment. So one judgment in 1,000, that is randomly selected, stratified random sampling. That way, so by selecting sampling, you can able to study. So because there is a belief that these judgments cannot be studied by random sampling technique. You can very well study because you are not minding about the outcome of the judgment. You are minding about the content of the judgment. You are minding about the thing. See, let me tell you. Suppose you have a hypothesis. The already I have given the hypothesis. The way of quoting foreign judgments, the way of quoting foreign judgments by the judges of the Supreme Court is steadily decreasing. What I mean by steadily decreasing, when immediately after independence, we have a fancy or we are influenced by Western system. So we used to quote most of the judgment. So even today, if it is a contract, we used to quote only foreign judgments. We are not quoting Indian judgments. So quoting foreign judgment, yeah, it is. So if anybody is interested, you can take the trend of quoting foreign judgment steadily decreased after independence. So you can take it, and there you can take its sampling. This is the sampling. I am taking it random sampling. So by random sampling, you can select the samples, and thereby the point I'm trying to say, by using sampling judgments can be studied. It is possible because our universe is 36,000 judgments. When you say the population is 36,000 judgments, then from 36,000 judgments, you can do anything. That way you can proceed. So there's a point I'm trying to say. Berger definition, here another addition is you can use this technique even for sampling, and thereby you can study representative one. So representative one, from particular to general, by studying this representative sample, you are trying to understand the whole population. That is the meaning of that one. So this is about Berger's definition. Then now, next one is I would like to introduce the modern definition of content analysis. So modern definition, next slide. Modern definition of content analysis. It is Berelson is a very pioneer. Berelsen is a very popular person in content analysis. Please move on to the next slide. Berelsen's definition of content analysis, everybody must know if you are interested in using this one. So I have already quoted this scholar earlier. Content analysis is a research technique for the objective. See, when we come across modern, they are using the word, our pattern, subject, objective, systematic, and quantitative description. Objective, systematic, and quantitative description of the manifest. My dear students, make a note of this one. Manifest content of communication. Manifest content of communication is a very important one. I'm not going to take it. There are two important things in interpretation of statutes and other things concerned. One is manifest content and latent content. So in an interpretation of statutes, grammatical school is there and the historical school is there. Another is a liberal interpretation and a strict interpretation. When you go through all these interpretation, this manifest content is one concept, and liberal construction or latent construction is another concept. So Berelsen is of the opinion that whenever we come across manifest content, in manifest context, the meaning is it's definite, it's unambiguous, it is clear. So when we come across this one, objectivity, systematic, quantitative, all these things are there, the communication is very clear. So that way Berelsen defines. And the next scholar is Kimberly A. Neuendorf. I have given this scholar's book also. It is related to content analysis, a guide book I have given. You can. It is also available in the internet. It is available in the soft copy. You can read it. So this scholar, Kimberly lady, content analysis may be defined as the systematic, objective, quantitative analysis of message characteristics. So underline the word message characteristics. What is the every message is characteristics. I don't like to introduce theory of this message or theory of this one. I don't like to confuse you right now. So message characteristics, it is very popular. It includes both human coded analysis and computer aided text analysis. My dear students, in this lecture, probably I will be introducing nearly 10 software terms. One such software term is this CATA, Computer Aided Text Analysis, CATA. So this computer aided text analysis, it is a computer coding and human coding. Human coding, nowadays we need not go for human coding because artificial intelligence, it minimizes. In one day, you can minimize 1 year work in with the help of artificial intelligence. So if you know the nuances of this coding, computer-aided text analysis or this software, you can minimize. So that's why I have been again and again saying 2.5 years you can get a PhD if you take an appropriate topic and you know the appropriate technique. So that way you can do that. So the next definition is our own popular definition. It is Klaus Krippendorf definition. Next slide. So content analysis is valid for studying text. So valid for studying text. So I am another research methodology I would like to use. Whenever you come across any book reading, research book reading, you may come across a square bracket, square parenthesis. When you come across a square parenthesis, I use this one, judgments in square bracket. So when you come across a square bracket, it means the word within the square bracket is not originally used by the author. The person who is writing this book or writing this dissertation or thesis is using. To differentiate that one, you have to use this square bracket. So that way, in Supreme Court judgments, you may come across this. The highlight is emphasize. To emphasize this one, they used to highlight or they used to in italics form. So this way, it is a research methodology format. So square bracket means the word is not in the definition. I am using for our convenience. So it's a very relevant one, useful one. So content analysis is valid for studying only text, only judgments, not people. You are not studying people. You are not studying the judge. You are not studying the characteristic of judge. Please make it a point. It is reading the text, not reading the people or a judge. He has his own approach to analyze data, text, or judgment. I am using this judgments within bracket. So wherever you come across text, it's judgment. That stems largely from how the object of analysis content is conceived. Underline the word content is conceived. When legislation is drafted, when a judgment is drafted, keeping in mind what they kept in mind. What's that meaning? What is their conception? That is very important. So the content is conceived. Now, how it is interpreted, that is the point. So judgment is to be understood in the context, in the context when it was conceived by the author of that judgment. So this is another definition, right? Please move on to next one. Uh, Next slide. There are 4 myths. It's the easy area. We can simply pass on to that one. But to make my students, to make it interesting, make it relevant, I am using this one. So the scholar Kimberly A. Neuendorf, she introduced 4 myths in content analysis. She says people are thinking content analysis easy. Is it easy? If you take it is easy, it is easy. But if you think it is difficult, it is difficult. So content analysis as easy or as difficult as the researcher determines it to be. It is not necessarily easier than conducting a survey, experiment, or other type of study. So not necessarily easier than conducting a survey, experiment, or other type of study. So when I say in 2 years' time, you can do all these things at home, don't come to the conclusion it is so easy. Conducting a survey experiment, it is difficult. For some people, mixing with the people population is comfortable. So if you feel it's easy, it's easy. If you feel it's a difficult, it's a difficult. So don't come to the conclusion that content analysis is easy. It is easy if you take it. If it is difficult, if you take it, if that's a difficult. Then the second myth is the term content analysis applies to all examinations. The second, please pass on to the next one. The term content analysis applies to all examination of message content. People are thinking that it can be used in all messages. No. Neuendorf, Kimberly, this is very specific. The term does not apply to every analysis of message content. So if there is a scribbling, with the scribbling, can you able to do the content? No. It applies only to those that meet a rigorous definition. So content analysis is applicable only after following the procedure, after following the rigorous definition of the content analysis. That's very important. It's not easy or difficult. It is not applicable to all. It is applicable only to selected items which are rigorously defined. Then the third myth is, all these myths you can easily follow. Third myth is anybody can do content analysis. It does not take a special preparation. So please pass on to the third one. The third myth is anyone can do content analysis. It does not take a special preparation. Is it so? No. Kimberly says, indeed, anyone can apply content analysis, but only with the training. You need some training. And with special substantial planning, you need training and there is a systematic planning, then only it is a very easy method, you can apply it. So this is a third method. She broke that third method. The fourth myth is content analysis for academic use only. I'd like to stress this point, this myth. Content analysis is for academic use only. Sir, you are telling all these things after completing masters, after completing research. Will this content analysis will be useful? Yes. I am emphatically telling you, if you learn this technique, you will be a most wanted hard cake in legal firms. Legal firms, they are expecting people like you who are an expert in content analysis, who are an expert in using artificial intelligence with the help of content analysis, and you will be, and I'm confident with more than 1 lakh or something like that, you will be given. So, good English, good ability to handle artificial intelligence, and the ability to use content analysis. So, it has wider application due to the big data and artificial intelligence. Big data and artificial intelligence in this world, it is a wider relevance. So these are the points that I am not saying. I am exaggerating certain things, emphatically saying certain things. It is Kimberly's myth and the breaking of the myth. Now let me pass on to the next heading, artificial intelligence. So my dear students, what is this artificial intelligence? Please move on to the next slide. Artificial intelligence, it is a set of technologies. Please try to follow. It is another myth. Easily you can break it. What is artificial intelligence? You are using artificial intelligence today. In the morning, I wanted to ascertain what is the percentage of Indians, graduates, who are using this smartphone. When I put it in the search, immediately comes 90% of the graduates in India, they have the smartphone ability using this one. What's this? It's artificial intelligence. So artificial intelligence is a set of technologies that enable computers to perform a variety of advanced functions, including the ability you see. See, the phone, in the phone, only if it shows your face, some of the phones are opening. It is face recognition. So it is to the ability to see, understand and translate spoken and written text. When you speak, it types. So what a beautiful. That's why I used to say the nowadays people are not going for typewriting classes. They are not going for steno work, all these things. Why? Typewriting, steno, they are obsolete. Like these, what's called on this, sometimes back, this telegram. Telegram is not at present available. It's completely removed. In course of time, this the removal of the telegram, typewriting institute and all these things will be simply because this computer system, it uses everything. Therefore, if you are interested in knowing the speedy typing, you can go for it. Otherwise, typing, it is automatic typing. So therefore, understanding and translate spoken and written text language, analyze data, make recommendations. So the text, all these things, judgments, make recommendations more artificially is doing wonderful thing. So what I'm trying to say, artificial intelligence simply, it's a set of technologies used in computer that minimize our work, that understands us. Next one is, I'm introducing another important nomenclature name. Natural language processing. Please move on to the next slide. NLP. NLP is called natural language processing. It's a subfield of computer science. In computer science, natural language processing is a subfield of computer science, and artificial intelligence, it is part of artificial intelligence that uses machine learning. Most of the students may be knowing this machine learning. What's machine learning? Human beings, we are learning. Similarly, the machine, it is capable of learning. Our learning is not similar to that of machine learning. Machine learning is algorithm. It is a binary, algorithmic. So it knows only 0, 1. Everything is converted into 0, 1. So machine learning and deep learning, machine learning, they are part and parcel of artificial intelligence. They are helping. These two technologies, set of technologies, enable computers to understand and communicate with the human language. So when I said that in the morning, I asked the computer, what is the population, what's the percentage of population of Australia to the population of the globe? I know India's population is 18% of the global population. I would like to know for a comparative study, what is the population, global population percentage of Australian population? Immediately, within a fraction of a second, it says 0.33% of Australian population is the global percentage. So when I speak, it takes, it types and gives the answer. That is what is called. This is the importance of this machine learning and deep learning. Computers to understand and communicate with the human language. So natural language processing uses linguistic models and statistics to train the deep learning technology to process and analyze text data judgments, including handwritten text images. Handwritten images also. My dear students, I am going to introduce another very interesting thing. Handwritten text can also be taken as images and it would be typed. The technology has developed so fast. So that way it is. So machine learning is a subset of artificial intelligence, which uses algorithms that learn from data to make predictions. Let me introduce Chat GPT. Okay, our university and other government universities, institution, government law colleges, they are restricting on the use of Chat GPT. For submission of assignments, other things, Chat GPT you need not be using. But collection of data for the helping of the data collection, Chat GPT is a very useful one. Chat GPT utilizes machine learning to train on a vast text corpus and predict the subsequent word in a sentence based on the preceding text. When you are typing, half a word, you have a doubt what will be the spelling. The computer is assisting. This is the spelling. You can click and you can take the spelling. That way, the computer is doing that one. So, natural language processing is doing wonderful service. This one. What I'm trying to say here in this context is I am deviating 1 minute for this one. Dear students, I am jumping. I should not jump, but I may not find time to take that one. Survey research, we are saying. In survey research, we may say open-ended question and close-ended question. My understanding, students, in order to maintain objectivity, in order to codification, in order to quantify it, we are going for close-ended question. 3-point scale, 5-point scale, 7-point scale, we are going it. And you are compelling the respondent to select any one of the answers that you determine. It is okay, but unless otherwise, what is in their mind, you cannot have a good research. Therefore, open-ended questions and answers in the open-ended questions are equally important. But nowadays, the students, we are not very much doing that one, because if you collect 500 500 samples, in the 500 samples, if you take 2 pages of open-ended questions, or in every question, half a page, every respondent, if you have 10 pages, 5,000 descriptive answers. How do you take it? How do you quantify it? Without quantification, it's not possible. There, this content analysis, if you use in the open-ended questions by converting into everything into a text, and thereby if you are applying this one, then the open-ended question, which is a quality question, which is a quality research, quality-based research, this quality-based research is also can be analyzed with the help of artificial intelligence. That's a point I'm quoting it. Students, you please keep in mind, if I have an opportunity, you knock me, that time I'll explain it further. So even in open-ended question, this artificial intelligence helping you to do that one. So this is a point I'm quoting is. Please move on to the next slide. Yeah. Oh, previous slide, there's a point in the previous slide, please. Natural language processing provides the understanding of grammatical structure and semantic. Semantic is literal meaning. These results allow a seamless translation of the text to other languages. Text mining, data mining, text mining refers to data mining. So deep learning is that technique in computer that is using in the data text mining that shows the relationship between the words. See, for instance, you may come across superlative degree. It is inferior to, superior to, greater than. Suppose if you type inferior, then the next word the computer says to. Greater, the next word is expected to be than. So in drafting thesis, error-free thesis, these are very, very important. But there is a small problem. Are you going to use American English or British English? In all computer languages, it's American English. What's the difference? Instead of yes, they are using Z. So small things that way you have to correct it. So this seamless translation of the text to other languages. Text mining shows the relationship between the words in the text. It analyzes word frequencies and patterns. In those days, some 20 years back, when you did research in content analysis, simply we can say in these 1,000 pages, this word liberty, personal liberty, repeated in 100 times. That way, and the repetition of this word is whenever you come across liberty, the prefix personal liberty, it is there. Whenever you come across a liberty, then the subsequent thing, liberty of thought, expression, it is. That way the pattern is described. That was. Right? The world has advanced so fast, and besides these type of frequencies and patterns, there are much more things. This deep analysis technology of computer science. It is. What is deep analysis? Deep learning is the type of machine learning that uses artificial neural networks to learn from data. Neural network. Neural means neurons, brain. So neural networks are inspired by the human brain, and they can be used to solve a wide variety of problems, including image recognition, natural language processing, and speech recognition. These are the things which are used in the deep learning. Therefore, whether you understand this deep learning or you are understanding all these things, in course of time, when I understand you guys, you are very young, you have a good opportunity to learn a lot of things, you can understand. So let me pass on to the next slide. So next slide is related to natural, yeah, yeah. This another heading, softwares to use content analysis. I told you I'll be introducing nearly 12 terms. Here is another important term. This will be. You need not note down. It will be available in the YouTube. You can note it leisurely. The softwares to use content analysis. What are the softwares that are used in content analysis? So computer assisted qualitative. See, underline the word qualitative data analysis softwares. These are so CACDAS, CAQDAS. So computer assisted qualitative data analysis software. The main function of this CACDAS is not to analyze data. Please underline, it is not to analyze data, but rather to aid the analysis process. How it is to be analyzed, how the data are to be analyzed, that way it helps. So CACDAS is a software that's not literally analyzing data, but it helps the analysis process, how to analyze it all this way, it helps. So one such CACDAS is MaxDAW, MaxQDAW. So Max Cuda means this Max Weber. Max Weber being a great sociologist, his name is given to this software. Max Weber Qualitative Data Analysis. So Max Weber's qualitative data analysis is one such software. It helps researchers and analysts. So researchers are analysts. You are from this day, you can, if you want to be a researcher or in content analyst, you can very well call yourself as analyst or analytical analyst to gain insights from written or text documents, including answers to the open-ended questions in a survey. So Max Weber, as he's a very great sociologist, he introduced in his name, they introduced the qualitative data analysis software. So open-ended questions in a survey can also be used in this way. So this is a very important one. Then next one is next slide. MaxQDA, I'm explaining a little bit deeply the advantages. MaxQDA is the tool of choice for mixed method experts, providing established tools like frequency tables, charts, and cross tables. When you sit with the software engineers, when you sit with the statisticians, when you sit with the data analysis, when you give the data, the next fraction of second they will give, sir, can I give this table or this type of picture? Or so it can be, the data can be picturized in different form, like frequency tables, charts, and cross tables. All these things are possible. It is possible because of MaxQDA, Max Weber's qualitative data analysis stats module for statistical comparisons such as descriptive and inferential statistics. Here you please come across, I am using the word descriptive statistics. We have been dealing with judgments. Judgments come across descriptive statistics. Here we are also clubbing in descriptive statistics, these inferential statistics, provided if it is related to sampling, if it is related to survey research and open-ended questions. So descriptive and inferential statistics, cluster analysis, and correlation. For the first time, we are using this one, correlation, because we are using this inferential statistics, we are using this qualitative data, or we are using survey research. That's why this correlation comes across in this one. So these are the things. Please move on to the next slide. So the dawn of CAXDAS was marked by the development of a program called, please underline this word, here artificial intelligence began to take off its wings. Non-numerical unstructured data indexing, searching, and theorizing, NUDIST. They use the word easily to remind in mind, keep in mind, NUDIST. What is NUDIST? Non-numerical, it's a software. Non-numerical, unstructured data indexing, searching, and theorizing. It was specifically designed for qualitative data management in the 1980s. Now we are after 40 years. So in the qualitative analysis, this NUDIST, it was in use in the 1980s, and it's another development after MaxDoc QDA. So this is, please move on to the next slide. My dear student, please make a note of this software. It's a very important software. NVO. VO you may come across in property, transfer of property you may come across. Property can be transferred from one living person to another living person. VO, we are using the word VO. VO means one living person to another living person. This NUDIST VO, it means this a non-numerical unstructured data indexing, searching, and theorizing. It was an old one, 1880s, in the 1980s. In the 1980s, they introduced, now they modified, improvised by using N. New, you can take it's a new. So NVO is a computer software program that allows the researcher to manage, analyze, and visualize qualitative data and documents systematically and individually. So NVO, keep in mind, this is very useful software. This NVO has its root in the NUDIST. It was first renamed to simply N. They add the word N, prefix N, and went through several iterations, several improvisation they made. NVO is derived from the word vivo. Vivo means meaning, within the living organism. was first released as NVO 2 in 2002. So now 22 years earlier it was used. Now it is in a different form. It is used. So please move on to the next slide. So NVO is used for qualitative and mixed methods research. So mixed research means it can be used in qualitative as well as in quantitative research. Specifically for the analysis of unstructured. What do you mean by unstructured? Any data, whether it is structured or unstructured, NVO can be used. Unstructured text, whether it is audio, video, and image data, any type of data. So, my dear students, we are lawyers. We are doing research in law. We are very much bothering about only in text. If you are entering into a legal firm or other software company, you can do all these things. But as far as text is concerned, including but not limited to interviews, focus groups, survey, social media, and journal articles. In this area, this NVO is of immense use. So NVO has features such as character-based recording, rich text capabilities, and multimedia functions that are crucial for qualitative data management. The strength of NVO lies in its high compatibility to research design. That's why I'm emphasizing this one. Whenever researcher, you have a research design. The research design helps you to draft research questions. This NVO is very much useful and it is compatible. Its compatibility is very high in research design. Therefore, for the researchers, it's very useful. So these are the important things I'd like to say with reference to software. Please, next slide. Before moving on to the next heading, please, next slide. Yeah. Before moving on to two examples, I would like to, I have to slowly go to that one. I want to impress my students, masters and researchers that there are nearly 10 softwares. Such a very interesting field in software regarding text analysis. We can use it because they are not coming to judgment analysis. They are simply confining to text and other things. And most probably this business administration and others personnel, they have encroached this field. We have to, it is our domain. We have to enter into it. There is a system called KIRA, K-I-R-A, KIRA system. KIRA system claims that its software can expedite the process by up to 40%. As a beginner, if you and me, if we are using, we can save 40% of the first time user. If you are an expert, you can save 90% of the time. So what a person can do a particular thing in 10 hours, he can do it in 1 hour. So this KIRA system. Then another thing is all capital, Leviton. Leviton is another software. It's a cloud-based tool, can swiftly read contracts in 20 languages, 20 language contracts extracting. Plus business law students, I have designed in such a manner to suit all the 13 branch students. So Leviton, it is useful in this area. It's a cloud-based tool, can swiftly read contracts in 20 languages, extracting vital information such as payable of rent, maintenance cost, and expiry dates. Then the next one is eBrevia, E is small e, Brevia, Brevia. It claims to analyze over 50 documents. All these things are not there. I am pointing out. Please bear with me for a few minutes. I will list out. It's very useful for you. So next to Leviton, this eBrevia claims to analyze over 50 documents in under 1 minute. In 1 minute time, it can read, analyze 50 documents. JP Morgan. JP Morgan is another software. It was developed by this Morgan company. It's an in-house legal technology tool and an artificial intelligence program that can extract 150 attributes from 12,000 commercial credit agreements and contracts in a matter of seconds. In a matter of seconds, 12,000 commercial credit in with 150 attributes. Thought River. So Thought River is another software. Thought River focuses on risk management by handling contract reviews, portfolio assessments, and investigation. Lee Gigs, LAW, LCAPS, Gigs, GCAPS, GEX. Lee Gigs employs machine learning, text analytics, statistical benchmarks, and legal expertise to validate contracts based on predefined policies. The company claims that its software can reduce cost by 90% and contract review time by 80%. So 90% cost can be minimized and the time can be minimized by the tune of 80%. Next one is a very useful one. Legal robot. LCAPS, legal robot, RCAPS, robot aims to provide lawyers with advanced analytical capabilities. So next one is my observation. ROS, ROS Intelligence supports lawyers in their legal research endeavors by offering natural language research capabilities that allow lawyers to ask questions and receive relevant information, including recommended readings related to case law and secondary resources. It's a very useful software. The next one is case text case. We are very familiar with case, CASE, CAPS, text, one single word, text offers CARA, CARA, a powerful tool that enables lawyers to anticipate opposing counsel's arguments by finding previously used legal opinions. See how interesting it is. This software, it says, this software is a tool that enables lawyers to anticipate opposing counsel's arguments by finding previously used legal opinions. If this advocate is going this way, he will raise this question. That way it goes. And the next one is, and it's going on, and I'm going to stop it with this. E-discovery, small e electronic discovery software can analyze large volumes of legal documents, including emails, contracts, and court transcripts. These are some of the softwares that can be used in artificial intelligence for a better, effective use of our research. Dear students, with this, now I am moving on to the applied aspect. I point out what is the meaning of content analysis very briefly. I have pointed out what is the relevance of this artificial intelligence. So we are in a world without relevance, we are not doing anything. So relevance. This artificial intelligence, I emphatically stated that it is relevant. Now I have taken two research work. One is a foreign research work, another is Indian research work. This foreign research work, this one, example research by CA with CATA, computer-aided text analysis with that. This research is there. It's a research done in Ukraine. So computer-aided text analysis, content analysis is intended to be free from bias. Hence, computer algorithms are effective tools to maintain objectivity. My dear students, up to this point, it may be a little bit technical. Now you can relax your mind. You just observe how they are using it. So in the Ukraine research, a handful of researchers they have done it. Handful of researchers, nearly 6 researchers, they have done research on this, and they have come to this conclusion. So they are of the opinion computer algorithms are effective tools to maintain objectivity. Computers can quantify the occurrence of certain words or phrases over time, as well as correlations between certain words. The correlation means if one word comes, that word will come, correlation. Once computer algorithms have mapped those data, researchers can identify larger patterns and themes. This is a prelude or introduction to that one. Now let me introduce the actual. Next slide, please. Yeah. This is the work done by the Ukraine scholars. Content analysis of court decisions. A GPT-4 based sentence by sentence data generation and association rules mining. It is done by West Ukrainian National University. Here we are using the word GPT. I said one dozen word GPT is the meaning of GPT, acronym for GPT is generative pre-trained transformers. Generative pre-trained transformer is in a short form, it is GPT-4, fourth version. It is shown as I'm giving it only for research point of view, for understanding. So I have taken that particular article and I'm using it only for our researcher. So please move on to that one. This article is also available in the internet. Those who are interested, you can read this one. So next one is, I would like to use here, there is another software called Spellbook. Spellbook, it's not in the slide. Spellbook uses GPT-4 to review and suggest language for your contracts and legal documents. Write in Microsoft Word. Work through complex legal arguments with surprising accuracy. Spellbook is trained on case database from libraries and statutes. Analyze entire contracts and documents holistically without running into token limits. So our popular software is Westlab. So Spellbook is another software you can keep in mind. Please move on to the next one. Next slide, please. Please, can you pause, go back to the previous slide? So, yeah. The findings of the research, Ukraine research is this. Research abstract. Court decisions they have taken. They identified the relationship between the circumstance of the cases and their outcome. So on the one side, circumstances, on the other side, outcome. In this article, in the Ukraine article, this article applies to the use of GPT-4 language model from the OpenAI. Another term you have to keep in mind, API, Application Programming Interface. Application Programming Interface, by using this one, they have analyzed this one. See, try to understand the relevance of the computer technology used in research. Please proceed to the next slide. In the introduction, I said, when you are interested in content analysis, the most important concept is units for codification, unit of analysis. So necessarily, as we are dealing with the Supreme Court judgments, necessarily we are dealing with the written judgments which are reported, which are available in the archives of the Supreme Court of India, and we are taking. Suppose if the students are very particular, as the Supreme Court is functioning only on the basis of bench system, except admission of cases and other things. So a division, 2 judges are there, 2 judges, 3 judges, and it goes on like that. So here, unit, you can take it as a judgment, and within the unit, you can take an opinion of a single judge. That way you can, so units for codification. What I'm trying to say, in the Ukraine scholar research, the API is a helper that lets the researcher to use open artificial intelligence smart programs in research projects to generate the necessary facts from unstructured text documents of court decisions. Unstructured text documents of court decisions and association rules. So on the one side, court documents, on the other side, it is association rules. By mining to identify patterns in the sets of criteria considered by the court when sentencing in similar cases. So it's a criminal case. This article is related to criminal judgments. So criminal cases, they have taken circumstances, and in another context, another variable, it is the application of laws. In another context is whenever a lesser, lower punishment is given on the basis of taking into consideration of so many factors, the occurrence of crime is more. That is a finding. It's a very interesting finding. Very important, this one. So these are the things. So they unified the units for classification is codification is that. Please move on to the next one. So next one is a data set. What's the data set? The analysis is based on a collection of 10,000 texts of sentences. Imagine 10,000 texts of sentences in criminal cases from the Unified Register of Court Decisions of Ukraine. It's a very big task, but artificial intelligence helped these half dozen researchers to arrive at effective analysis. The findings. It was revealed that offenders regarding whom the court made a soft decision in the form of conditional convictions or early releases have a higher risk of committing recidivist crimes. So they are going on repeating it. So this is the very interesting finding, very important finding. Any criminal law student can take it, or you can do it in this way. So this is the point I would like to emphasize. This is not our research, it's a Ukraine research. Please, in this context, as a model, we can take it. Please move on to the next slide. So artificial intelligence-based system can be used to analyze a large collection of legal documents. Now I'm summing up. Large collection of legal documents can be analyzed. This can be significantly simplified and accelerate the search for relevant information like judicial precedents, legal text, etc. So from this, what we can conclude in an era of big data, we are in a big data era. In discovery and analysis of judgments, the role of content analysis is very big indeed. So big data, it is useful and big necessity for lawyers to do this one. This is our observation with reference to the Ukraine article based on this content analysis. Now, let me move on to the second research work. It's an Indian research work. Please move on to the next one. The earlier one, it was CAPTA, computer-aided text analysis, or AI-aided assisted research. Now it is human-coded. See the difference? Because it was a research done in between 2010 and 2015, 10 years back. Therefore, this is human-coded. So human-coded research in Supreme Court judgments. Meaning of human coding. What I mean, human coding means the analysis researcher is going on reading and coding and all these things. It's a Herculean task, very difficult task. So here, human coding. What's human coding? Human coders are analysts. We can take it's a researcher. So researcher who by following a specific procedures classify the required written text message to avoid human subjectivity. 2 or 3 people can code each message independently, and by comparing their respective works, the content analyst verify the coding is reliable and objective. Again and again, we are emphasizing it must be objective. When a researcher analyst codify it, there may be some subjectivity. Therefore, parallelly, without any consultation, predetermination, if 2 or 3 persons parallelly, if they go code, on the basis, if they come to a somewhat concurrent, somewhat identical observation, identical codification, that is reliable as far as human coding is concerned. So only for understanding purpose, we are taking it. Human coding is a difficult job. In rare occasions, you can use it. But when artificial intelligence is there, you can simply rely on artificial intelligence. Anyway, researcher, we must know the technique. So human coding is possible, but this article, it is based on human coding. That's why I have taken this one. So please go on to the next one. Human coding article, model article. Example of human coded judgment. It's clearly stated an empirical overview of the Supreme Court of India. It is available in 2018 article by Aparna Chandra et al. Research methodology, I'm using the word et al. Because there are more than half a dozen scholars, they have done this research. The first scholar is Aparna Chandra, and we need not repeat the subsequent names of the authors. If you use the word et al, it means in methodology, it means others. So Aparna and others, they have done this one. It is done in National Law University, Delhi, in collaboration with the University of Chicago Law School. So, a descriptive account of the functioning of the court through an empirical analysis of all cases, underline the word, of all cases decided by the Supreme Court between 2010 and 2015. We are about to step into 2025, 24. So, around about 9 years back, before the previous decade, so 2010 to 2015, they have taken 5 years period, study period. So please move on to the next one. The approach is a quantitative one. The approach is quantitative and comprehensive, based on a data set of information drawn from all judgments rendered by the Supreme Court of India during the years from 2010 through 2015. They have collected, they have codified all the judgments from 2010 to 2015. The data set contains 5,699 judgments from 2010 to 2015, dealing with 6,857 cases. So these are the data sets. Please move on to the next one. So judgments in over 6,000 cases. So don't ask me why you are saying 6,000. Why? Because they are not taking into admission. Single judges, they are admitting. So 6,000, it comes to that tune. They are also around about 6,000 judgments we can take. So judgments in over 6,000 cases, as reported in the Supreme Court cases report. See, they specifically, it is the delimitation. Some other judgments may be there. I don't take it. I am taking from SEC, Supreme Court cases reported. Only that one I have taken. The scholars, they confine. So hand coded for information and a wide range of variables. The results and findings are several. See, this article, it is available in the internet. You can go through this article. That's why I've given the title also. This article contains 36 pages. It has 28 tables. Almost all the tables, it comes to the page of, comes to the tune of 1 page or so. So 28 tables. In order to save the time, in order to not to bore you, not to make you more tedious and monotonous, I've selected some of the things. In selecting the tables, I have used I kept in mind all the subjects, all the masters in mind. On the basis, I have selected these tables. So please move on to the next one. It's only for understanding, research understanding I am giving. Probably it will be very difficult to read, but my dear students, you please try to read this one. So this table, see how much information they have collected. It's a table 1. It is all the around 6,000 subjects cases are measured, quantified. So subject matter categories. What I'm trying to say, if any researcher of the 13 branches, if you start a researcher, you can quote this one. As per the research done by these scholars, in between 2010 to 15, in this particular area, say criminal matters, 29% of the cases are appealed to the Supreme Court. It's a starting point. So service matters, those who are interested in service matters, you can say 11.2%. So that way, I don't know whether it is visible there or not. It's a very small. I took it in a particular manner to show it to you. So please carefully note, it covers all the 13 branches. Criminal matters 29%, service matters 11%, ordinary civil matters 10%. See, comparative study, whether civil matters are more or criminal matters, criminal matters are more, 29% criminal matters and 10% is only civil matters. So then definition of what is criminal, what is civil, it is again. If you take service matters as a civil matter, it will go to the level of 21. So that way you have to define. Land acquisition and the requisition matters. Constitutional matters, very interesting. In the 5 years period, of all the 6,000 cases, only 6.2% of cases are constitutional matters. Let me tell you, if you take Justice DYC period, the percentage definitely will be more than 10%, because constitution bench more constitutional judgments. That way you can deal, you can introduce and analyze this one. Indirect tax matters and letters patient letters I'm sorry, letter petitions and PLI matters. Those who are interested in PLI, you can take. Direct tax matters, compensation matters, family law matters. Very well, you can start that one. Matters relating to judiciary, mercantile, labor law. Labor law students are there, you can take. So labor law in the 5 years period, what is the average? 1.8% of the cases from labor law. Arbitration matters 1.5. There are environmental law students, they are very much interested in doing research, only 1.3%. So whether it is environmental law, whether it is brought under constitutional law, it depends upon the interest of the students. So you have to. Content of the court matters, academic matters, appeal, rent matters, election matters. So election matters only 1.1%. Matters relating to lease, government contracts, etc. Matters relating to consumer protection. Say consumer protection only 1%. Mines, minerals, and mining. Company law, MRTP, 0.8%. So my interest is some of the students who are very much interested. What about human rights? So the human rights case, see, matters pertaining to armed forces, admission to education institution 0.4%, and habeas corpus petition 0.2%. Human rights and matters 0.1%. Only 0.1% comes to the Supreme Court with reference to human rights. So Admiralty, there are marine law students, Admiralty and maritime law, it is 0.1%. Of the 6,000 cases, in percentage is 0.1%. So if you start your research, you can start in the beginning. The quantum of cases reach the Supreme Court for its disposal of is this level. You can go. So please move on to the next slide. So case origin. See, another very interesting. If I'm interested in doing this one, when I was doing my first research in between 1980 and 1985, before coming to the law school, law college, Madras Law College, my friend, one of my friend, he did his research in urbanism. He introduced the word urbanism. It is depending upon distance from the city and transportation, all these factors. Distance from the city is one variable, and the transportation is another variable, and the education is yet another. That way he defines. See, please, you take into consideration case origin High Court. High Court of Punjab and Haryana. How many cases? 669 cases. Why? I don't know. 62% is reversal. High Court of Bombay, 607 cases. High Court of Delhi, 530 cases. My dear students, I'm not doing politics. If there is a branch in the High Court of Chennai, accessibility will be more. We will protect our fundamental rights. We will protect our rights. So people in and around Delhi, 530 cases, and Punjab is it's very close to Delhi, 46 cases. That way you can do the research. So proximity, in what way the proximity? There are people who are of the opinion that instead of going knocking the doors of the Supreme Court, let us take it as a destiny, let us take the suffering. That way they used to. Financial accessibility, access to justice, it depends upon so many factors. So literacy is one such problem, financial ability is another problem, distance is yet another problem. So Delhi, Allahabad, 502, Madras, from Madras, 368, from Karnataka, 367, from Andhra Pradesh, 301. It goes on, and in the other area, so it is decreasing. So distance and the Supreme Court, location of the Supreme Court, that's an yardstick. If you take whether it is in proportion to the population, definitely it's not. It's not proportionate to the population. That way, anybody can do a research in this way. So what I'm saying, you can take a beginning starting point for your research. Please move on to the next one. Don't think that I am boring you, but I want to create an interest because when it is in data form, you can do it. Next one is table 5, data and duration. It's very interesting. Very interesting. How long? See, in statistics, you may come across median, mean, median, mode, average, all these things. They are using it. What is the mean period of disposal of the cases? Date and duration, mean duration. Year filed in court of first instance 2002. Year decided in court of the first instance 2003. So in the lower court it is year of decision in the appeal 2008. Year filed in Supreme Court 2009. See, it started from 2009 and the verdict it reached a decision in Supreme Court in 2012. This is the longevity. One of you can take a study and you can do it. The delay of justice is a denial of justice. In this manner, how long does the court it takes time? That way you can take it. So duration of court below 1,784 days, whereas in the case of Supreme Court, 1,569 days. So totally it is more than 3,200, 3,300. 3,300 days means 10 years. So 10 years, if you are struggling, what will be the destiny of the person? That way you have to take. So for that purpose only I am giving. It is these are the things that it is analyzed by the scholars. Then next, please move on to the next one. It is table 8, average duration days in the Supreme Court by subject. See, another very interesting. It's not uniform to all the subjects. Once it is filed, whether it comes from the end, no. So there is an association between the nature of the subject and the duration taken by the Supreme Court in disposing the cases. Please look into the 40th one. Habeas corpus matters. It took only 190 days. It's very important, isn't it? Whereas in the case of maritime law students, admiralty and maritime law, 3,050 days, 10 years. So it goes. HRNC 2,776. So indirect tax matters. So let us take the constitutional matters. Where is the 16th one is constitutional matters. 1,593 days. 1,593 days means 4 years. So constitutional matter it took 4 years. It takes 4 years. Recently, you may come across constitutional matters 6 years, 7 years, like that. So this way, when you are finding time, please go through this one. Again, you may take a clue, lead from this one to start your work. All the 13 branches you have scope in this area. Then next one is reversal. Reversal is another important. What is the percentage of reverse? And is there any association between the quantum of reverse and the nature of the judgment? Reversal means High Court judgment is reversed. So in what way reversal rate? So reversal rate adjudication body appellate. So High Court of Sikkim reversal rate is 75. High Court of Orissa 73 reversal rate is. High Court of Jharkhand 65. So the lesser reversal means efficacy. I should not say that. I should not come to the hazardous conclusion, but prelude. So Chhattisgarh, Madhya Pradesh, Patna, Uttarakhand, Punjab, Haryana, Rajasthan, Gujarat, Karnataka, and Chennai, Madras. So Madras 59.9, 60% of the cases. So can you totally, you please look into the last one. 58.5%. So more than 58% of cases are reversed in the High Court. Whether High Court, see, I know High Court is the highest court of appeal as of right. SLP is special leave petition. If the Supreme Court permits, then only you can appeal. Otherwise, the destiny will come to an end, SLP. But highest court of appeal as of right is High Court. 58% of the cases, they are reversed in the Supreme Court. And what does it mean? I don't come to any particular conclusion. But if you have accessibility, if you have resources, if you have good advocacy, if you have all these things, there is every possibility 58% of the cases can be reversed. Then opinion of authorship. So far we are talking about cases. Now it is judges. So individual judges, opinions of the court. So total number of cases, in how many cases judges they give the opinion. So Justice B.S. Chauhan, 495 cases, in 495 cases, 45% of cases he has given opinion. And it goes on. And whoever you are interested, you can refer it in how many cases they are giving opinion. So the thing is, Altamis Kabir, why he is given in bold? No, I didn't give. V.S. Sirpurkar and Altamis Kabir, they are given in bold because the research they themselves, because in the case of Altamis Kabir, Justice Altamis Kabir, 63.5% it is opinion given. And in the case of V.S. Sirpurkar, who is known for his judge erudite scholarship, 57.1. So others are less than 50%. So in these two cases only, it exceeds 50%. Opinion authorship, opinion of the court. So opinions of the court, total cases, it goes on. And please, Justice Bonamati, of the 73 judgments, 47 judgments, opinion of the court. So 64%. That's why they are given in bold. And in the case of Syriac Joseph, 113 opinions, 5 only he gave opinion, 4.4. And R.K. Agarwal, only in 38 cases, 2 opinions, 5.3. That way it goes. Opinion authorship, concurrent opinion. So every concurrent opinion, dissenting opinion, all these things, they are concepts, they are very important. In chi-square technique, in correlation and other things, or trend analysis, all these things, they play a very vital role in descriptive statistics. So it starts with Madan B. Lokur and it goes. So see, out of 12,073 total cases, only 58 concurrent opinion. And dissenting opinion, only 29. So 59, 29. So that way you can say who is a top in giving dissenting opinion. Justice Gyan Sudha Misra, 6 dissenting opinion. So the percentage is given. For your study only, I have given. So I think I have bored you a lot, but I would rather go. But so to create an interest among you, these scholars, they have analyzed all these things and detailed. What I'm trying to submit to the students is, if you start, whether it's a doctrinal research or non-doctrinal research, whether it is for a dissertation or for a thesis PhD, there are a lot of clues you can start. Of course, it's a secondary. You can take a clue and you can proceed. And I want to proceed further. That way you can. Please move on to the next one. So I have given 2, please next one, factors for the growth of content analysis. All these things I have explained. These things are available in the slides. You can refer that one. So up to this one, what I'm trying to say, what I submitted, I have taken 2 concepts. One is content analysis. It is gaining momentum. Dynamism, very popular. Its applicability is very big. I have taken artificial intelligence. It is a very useful, effective concept. Don't come to the conclusion artificial intelligence is only an area of computer scientists. More than computer scientists or lawyers, this is a very interesting field. So I have taken 2 model study. One is a Ukraine study related to criminal law. Another is an Indian study related to the past of 2010 to 2015. I have substantiated the point. This way, we researchers, we can do empirical research, statistical research, content analysis, all these things. Now, the last heading is factors for the growth of content analysis. What are the factors that are useful in content analysis? This is, I would like to point out. See, now we are in a crossroad. The future is quite uncertain. Whether the artificial intelligence is going to rule the world or ruin the world, I don't know. People equally, they are divided. One group of scholars, pessimistically, they are going to say, once artificial intelligence acquired this consciousness, that is the end, it will take off. And we will be only like slaves. Another school says no. Optimistic school, it says that no, human beings, they are capable of adjusting with the things. We will know how to control artificial intelligence. We are prudential. We have witnessed all these things. Therefore, whether artificial intelligence is going to rule the world or ruin the world, I don't know. But for the next 50 years, software advocates who know artificial intelligence, who are capable of using artificial intelligence, they are going to rule the country. They are going to rule the world, 1 point. Second point, at the micro level, if you know artificial intelligence, the world is yours. You can be an expertise in that one. So artificial intelligence, it has an explosion. So explosion of internet and availability of vast amount of contents, text, judgment, it is. That's why it is a growth for content analysis. Second one is increasing sophistication of computers. So in 2014, I wondered, is it possible to translate all the Supreme Court judgments into Tamil? But all the judgments are, now it is possible. What was impossible, what was not at all possible in the last decade, it is easily possible now. So increasing sophistication of computers, which can use machine learning to recognize some content patterns without human input, such advancements will make content analysis faster and more accessible. So without human input, that's very important. So when you need human input, it's laborious. Without human input, we can do wonders. Then please move on to the next slide. So content analysis is used in a wide variety of academic disciplines. In the legal arena also, content analysis of historical judicial opinions can provide quantitative means for interpreting case law, specifically by conducting content analysis on past court decisions. Lawyers can gain insight into factors that might inform future rulings. Future rulings. See, you cannot read the mind of the person, but with the help of the judgments, reading the past judgments, this judge is going to deliver this case only in this manner. It is possible. With the wisdom of the advocates, the senior advocates, they used to say, but it's a general, it's a crude one. But the artificial intelligence, to the tune of 90% prediction, precise accuracy, is going to say. So that way it can predict. Please move on to the next one. Next slide, please. Yeah. So the scholar Kimberly A. Neuendorf, the book I have given, she herself lists out the circumstance under which content analysis can be used by lawyers, litigants. She herself says, false advertising cases. Experts have conducted content analysis to identify themes or terms that companies use in their advertisements. In defamation and consumer fraud and product liability settings, content analysis can help gauge public sentiment about given topic. Please move on to the next one. It's not my prediction, it is the author's prediction. So content analysts have assessed Twitter posts to understand consumer perception of a product. See how they are. So in event studies, content analysis can show when and how news is disseminated, and what is informed is in the public domain at certain points in time. When it is to be given, when it is useful, all these things. They predicted this one. Please go on to the next slide. So again, the same scholar. In what way it is useful to the law firms have used news coverage analysis of their high-profile clients as evidence to support change of venue motions. So what is meant by change of venue motions? If even today senior advocates and advocates, they are of the opinion, if this case comes to this court, we will have a negative result. They will not bring this one. And sometimes if it is possible, there is a concept called a change of venue. A change of venue is a legal option. A motion for a change of venue is a legal request for a party to transfer the case from one location to another location. It's possible. So this lady, Kimberly, she says this is possible. In addition to these specific scenarios, content analysis can be vital for e-discovery, electronic discovery, and organizing tool in case that draw upon voluminous number of documents. So with this, my dear students, I think I have bored you a lot, but whether it is boring or it is a monotonous or it's a bombardment, I deliberately wanted that the world is going in this direction. The Law University, thanks to Tamil Nadu, Dr. Ambedkar Law University, largest law university with all technology know-how, with all equipped, well-versed scholars, professors, and faculty members. The dynamism of the Vice Chancellor is there. With this background, if you are not using this opportunity, you are missing the bus and you will find handicapped in the future. With this note, I will give room for questions. I am willing to answer questions if there are. Thank you very much. Thanks for the opportunity. Once again, I'll reiterate, thank the Vice Chancellor, Honorable Vice Chancellor, Colonel Professor Dr. N.S. Santosh Kumar, the Dynamic Director, Professor Balaji, PG Director, Dr. Professor Kumudaratna, the Research and Publication Director, Professor Harita Devi, and the coordinator whose efforts bring all these things into documents, everything, Dr. N. Anbarsi and his team. I have to appreciate the team because the team, they are doing a wonderful thing because they are putting everything in the slide. So I can give the content, but the visibility, everything, it depends upon the slide makers. Thanks to the organizers, thanks to the team, everything. Once again, I'll leave space for questions.
It was an incredible session.
Thank you.
We open the floor for.
Yeah, I'm willing to answer.
Good afternoon, sir. Myself,
Good
K.
afternoon.
Hariharan from Environmental Law and Legal Orders. My question is related to content analysis. Content analysis is referred to the textbook and judgments.
Yeah.
Textbook is referred to individual rights passage and judgment is refers to judges.
Okay.
But your point of view is textbook it's not based about only the peoples and judgment is not based about only the judges.
1 minute, Mr. Hariharan. I am using the word text. It does not mean textbook. It does not mean textbook. Text is any written words. See, if you take a particular act, it's a text. If you take a judgment, it is a text. If you write one page of essay, it is a text. It does not mean textbook. So text I equate with a judgment. Whatever you want to use, you can use it. I have substituted that word text to include environmental law students, you may be very much aware of it. When you are administering interview or questionnaire, there is a concept called open-ended question. In the open-ended question, you are asking, what is your opinion about the present pollution level? They will give their
Okay.
own answer, not in one word answer, not in one sentence answer. They will go on write one page. They may say, sir, the present torrential rain in 3 hours, 36 centimeters rain in Pamban, it is because of the ecological disaster. If they say, they will go on write in one page. Say, this is a text. This text, previously we cannot codify it. We can take it only for interpretation. Now, this content analysis is useful technique even to codify that one.
Yes, sir.
So if you are using it, it's a wonderful device. That's the point, Mr. Hariharan.
Okay, sir. Thank you so much, sir.
Thank you.
Thank you so much for your enlightening speech also, sir.
Thank you. Thank you.
Thank you very much once again, sir.
Yeah.
Now I will call upon Mr. Arun Anthony G for rendering vote of thanks.
Okay.
Good afternoon, sir.
Good afternoon.
Greetings to you all present here. It is my duty and privilege to thank our Honorable Professor Dr. Vadangamudi sir, the former Vice Chancellor of Tamil Nadu Dr. Ambedkar Law University, who is known for his scholarly work. Dear sir, thank you so much for your intelligible lectures, especially today's topic on artificial intelligence and content analysis of Supreme Court judgments. It was indeed inspiring and enriching one, which kindled the fire of knowledge and wisdom in legal education and research methodology through various concepts, new technical terminologies, software, and subject matter category. Sir, we sincerely appreciate and thank you from the bottom of our hearts for your perseverance in taking so much painful effort to impart education and inculcate knowledge among young minds. This will certainly empower us to bring out more solutions for the existing socio-economic problems, to uplift the needy and the marginalized communities, to create an egalitarian society with peace and prosperities, generation after generations. It will be apt to say here, from the lines of the famous ancient scholar, poet, and philosopher Thiruvalluvar in his poem Tirukkural, numbered 398. ஒருமைக்கண் தான் கற்ற கல்வி ஒருவருக்கு எழுமையும் ஏமா புடைத்து. அதன் பொருள், ஒரு தலைமுறையில் பெறும் கல்வி அறிவானது 7 தலைமுறைக்கும் பாதுகாப்பாக அமையும், which means a person who acquired learning grains in one generation will be a protection for 7 generations to come. Sir, we assure you that the zeal and enthusiasm of seeking knowledge will never be quenched within us, and our knowledge and learnings will shine like a beacon of light in the darkness of ignorance. I also take this opportunity to thank our Colonel Professor Dr. N.S. Santosh Kumar sir, the Vice Chancellor of Tamil Nadu Dr. Ambedkar, who stands as strong as a banyan tree, too deep rooted and committed to take care of all welfare of everyone in his office given. Our Registrar Ma'am, Dr. Gauri Ramesh, Dean of Students, Professor Dr. Balaji sir, PG Director, Professor Dr. Kumadaratna Ma'am, our Faculty Convener, Professor Dr. Anbarisi Ma'am, who is the backbone behind this successful lecture series, and HODs of all departments, teaching faculties and non-teaching staff, and all students for your guidance and support. And last but not the least, I sincerely render my thanks to all the students, coordinators, and volunteers for this wonderful program. Once again, thank you so much, sir. Kindly support us continuously in our learning process. Thank you, one and all.